Good afternoon. Thank you for joining us today. As many of you know, my name is Deborah Linder. I'm the chair of the Compensation Planning and Employee Benefits Group here at Fredrikson and Byron. And I'm joined today by my colleague, Thomas Henke.
Hello,
Thomas, you want to say hello? All right, very good. We, of course, wish that we could be with you live and in person, interacting with you live, answering your questions live. Unfortunately, that's not the world we live in today, so here we are at yet another virtual webinar. And we're going to spend the next hour or so talking with you about the 2020 benefits update. We do have a few things to share with you. There's been some legislation that has been passed, some guidance issued by the IRS and the Department of Labor over the course of the year, and maybe a few insights into what to expect for the balance of the year and into 2021. Before we start, a few housekeeping items. At the bottom of your screen is a toolbar with various tools that you might find useful. You can certainly resize those items or move them around as you need. But the most important one for us is the Q&A tool. That is how you will submit questions during the webinar, and we'll try to answer those after our presentation. If we don't get to them today, then we will try to follow up with you after the webinar today. Okay, so with that, let's get started. And I'm going to kick it off with a review of the Secure Act. You may recall that last year we spent some time reviewing the Secure Act. Not sure what's going on with the slides here. We spent some time reviewing the Secure Act last year in our breakout session. I'm not going to go through all of those provisions in detail today. I wanted to do a few of them just to keep them top of mind, and then there are some that we have received guidance from the IRS. So the first one relates to plans that have an automatic elective contribution feature. If you have that kind of feature in your 401k plan, you may also have an auto escalation feature that increases participants' deferral percentages, perhaps up to 10%. The cap had been 10%. The Secure Act increased that to 15%. Now, over the course of 2020, I haven't had many, if any, employers looking at increasing their cap on their deferral percentages. With furloughs and layoffs and pay freezes and the like, this probably hasn't been the best year to do that. But it's something that you might want to think about going forward as we hopefully get through all of this. The second item that I want to talk about relates to safe harbor non-elective plans. These are the safe harbor plans that provide for a fixed 3% contribution, whether or not the participant is making salary deferral contributions. The Secure Act eliminated the annual notice that is required for this type of safe harbor plan. Now, in talking about this with some third-party administrators, I have heard that some administrators are recommending that you still provide the notice yet for next year. So if you're a calendar year plan, that deadline is coming up on December 1st. Even though the Secure Act eliminated that requirement, they are suggesting that you still provide the notice because, one, we don't have IRS guidance on this particular item, and two, if you want to reserve the right to suspend the safe harbor non-elective contribution during 2021, then you should provide that notice still on December 1st. So I would encourage you to talk with your third-party administrator and your benefits consultants to see what they might recommend in that regard. The second item relates to plans that want to add a safe harbor feature. If you want to add the safe harbor non-elective feature to your plan, you have the ability to do that anytime during the year up to the 30th day prior to the end of the plan year. So for calendar year plans, anytime prior to December 1st. After the 30th day, you can still add the feature, but you would have to provide a 4% contribution, not a 3% contribution. Again, we're still waiting on guidance from the IRS with respect to how that works, but it might be something that you'll think about going forward. Okay. The next item relates to long-term part-time employees, and this has received some attention from a number of my clients that do use part-time employees on a fair basis. Long-term part-time employees must become eligible to make salary deferral contributions if they work at least 500 hours per year during a 3 consecutive year period. Once that happens, they must be eligible for salary deferral contributions under your plan. Now, even though they're eligible to make those contributions, they are not required to be eligible for matching or profit sharing contributions. But you may want to consider making them eligible for safe harbor contributions, and we'll talk about that in just a second. The IRS recently issued some guidance that provides for how you should track service and when you should track the service. For eligibility purposes, you must start tracking their hours and their years of service starting January 1st, 2021. So for most plans, it's going to be 2024 before these long-term part-time employees become eligible to make salary deferral contributions. But for vesting purposes, the IRS guidance indicates that you must track hours for every 12-month period prior to 2021. And if the part-time employee works 500 hours during a 12-month period, they earn a year of service for vesting purposes. Now, if you don't have them eligible for matching or profit-sharing contributions that have associated with a vesting schedule, it's probably a moot point. But if these folks become eligible for that kind of match or profit-sharing contribution down the road, you're going to need to know what their years of vesting service is so that you can add them to the vesting schedule at the appropriate level. So you're going to want to talk with your third-party administrator, maybe your payroll providers, maybe your internal folks about how to gear up for tracking their hours and tracking their years of service for both eligibility and vesting. The next item relates to penalty-free withdrawals, which you can permit. This is an optional feature. You can permit these withdrawals from your 401k or profit-sharing plan up to $5,000 for qualified births and adoptions. And we do have some guidance from the IRS relating to this item. The IRS provides that the distribution must be requested within 1 year after the date of the birth or the date that the adoption is finalized. The participant must include the child's name, age, and tax ID number on the tax return. And these withdrawals are not subject to the mandatory 20% tax withholding. Voluntary withholding can apply, but they are not subject to the mandatory 20% withholding. These distributions are permitted from qualified defined contribution plans. So for example, your 401k or profit sharing plan. They are also permitted from 403B plans and IRAs, and from governmental 457B plans. So if you are a tax-exempt organization that has a 457B plan, this distribution feature, it cannot be added to your plan. Only governmental 457B plans can add this feature. The IRS guidance includes a definition of what they call an eligible adoptee, which is defined as a child under age 18 or a child that's physically or mentally incapable of self-support. But it does not include a stepchild. The guidance provides that each parent can receive this withdrawal. So if both parents are participants in a 401k plan, each of them can request up to $5,000. And if it's a multiple birth, then you can request, the participant can request a distribution for each child. So for example, if a couple has twins and each of them are participants in a 401k plan, then each parent can request a withdrawal of up to $10,000. There is a provision that allows the participant to recontribute the dollars back into the same retirement plan or the same IRA, not a different plan, but the same plan. And if they do, that's considered a rollover contribution. Quite frankly, I don't know that there will be a lot of participants who take an in-service withdrawal and then pay it back. So that may be a feature that doesn't get much use, but it is a part of the guidance from the IRS. Next, the Secure Act increased the age requirement for minimum distributions from age 70.5 to age 72, and also modified the post-death required minimum distribution rules, lengthening the time period from 5 years to 10 years, with certain exceptions for spouses, disabled beneficiaries, and minor children. But probably the big news that you need to think about are the lifetime income illustrations that will go into place next year. This applies to defined contribution plans like 401k and profit sharing plans. The Department of Labor issued guidance last August So this will become effective in 2021. Essentially, what you're going to need to do is to take the participant's account and translate that into an income stream over the participant's lifetime. You are required to provide two different disclosures, one that provides a single life annuity and one that provides a qualified joint and survivor annuity, assuming that the beneficiary receives 100% of the participant's payment for the beneficiary's lifetime. And you have to provide both of those disclosures, whether or not the participant is married. So if the participant is unmarried, you still have to provide both disclosures in the information. Now, one of the questions that we've had is, well, what assumptions should we use to translate that account? What interest rate, what life expectancy, and so forth. And the Department of Labor guidance has issued some safe harbor assumptions that you can use and probably should use for doing this calculation. Things like, when will the benefit start? An assumption around that. An assumption around the participant's age, which they generally assume to be age 67. The interest rate that should be used, the life expectancy that would be used, and you are also supposed to assume that the participant is 100% vested in their account. The Department of Labor guidance also includes model language for you to use in that disclosure, which I would recommend using. If you follow the Department of Labor's model language and assumptions, then you have some relief for liability for making these disclosures. The disclosures are required to be provided annually, but if your plan, like most, allows participants to direct the investment of their accounts, then it must be provided on a quarterly basis. So you're going to want to talk with your third-party administrator. Maybe you've been hearing about this from them already, but you're going to want to talk with them about making sure they're geared up to provide these disclosures to your participants starting in 2021. And I believe it's a one-year requirement, so it won't be until well into 2021, but you'll still need to start doing this relatively soon, because time flies, as you know. Okay. Let's switch gears now and talk about the CARES Act. Most of you have probably dealt with many of these provisions already. They became effective back in March, April timeframe, and I talked with a number of clients about whether they would add some of these features to their retirement plans. The first one related to a penalty-free withdrawal of up to $100,000 from various qualified plans and IRAs. And most of my clients added this feature just to make sure that employees could have access to funds if they needed them. If the employee receives the distribution, then the employee can repay it over a 3-year period, or they can include it in their taxable income over a 3-year period. But it is only available to participants that have been diagnosed with COVID, had a family member diagnosed with COVID, or had experienced adverse financial consequences as a result of COVID. And as I said, most of my clients that I talked with added this feature basically to protect employees. What we're finding, though, in the administrative reports that they're starting to receive is that even though they added the feature, they're seeing very little activity. Very few withdrawals have been requested as a result of this feature added to the plan, which I guess is good news because it suggests that folks are trying to preserve their retirement assets. The second feature relates to loan limits. And again, this is for participants who are either diagnosed with COVID, had a family member diagnosed with COVID, or who experienced adverse financial consequences as a result of COVID. The CARES Act increased the loan limit from $50,000 to $100,000, or from 50% to 100% of the vested account balance, but only for loans made through September 22nd, 2020. So this provision has actually expired. I guess we'll see as this pandemic continues whether there will be an extension of this relief into 2021 or perhaps the end of 2020, hard to say, but it's quite possible that we'll see this provision extended into 2021. You could also allow a 1-year delay in loan payments through the end of 2020, which would then also extend the term of the loan. Again, most of the clients that I talked with added these features to protect employees, to give employees access to funds if they needed them. But in the administrative reports that we're seeing, very few folks have increased their loan activity as a result of the CARES Act, which again, I think is good news. And the last item relating to retirement plans is the required minimum distribution for 2020. That distribution was waived for 2020, but you can choose to make it available. If the participant wants to take the distribution, they can have the option of doing so. Now, you may recall that back in 2008, 2009 timeframe, we had a similar situation with the financial crisis. The required minimum distributions were waived at that time, but you could make the distribution available as an option. I suspect that we're going to see similar language from the IRS that we used back in 2008, 2009, and that will probably be what most of my clients will do. They'll make the distribution available for 2020, but not require it. Okay. For health plans, high deductible health plans can cover telehealth and other remote care services and cover COVID testing at no cost. And we just recently had some guidance indicating that vaccines and CDC approved preventive care services should also be provided at no cost. And doing so will not affect the individual's ability to make contributions to a health savings account. So even though these are required to be provided at no cost, they can still make contributions to their health savings account with those services. Generally, this applies for expenses that are incurred during 2020 and 2021. A number of changes were made for cafeteria plans, and again, my guess is that you probably have dealt with these issues already, but my speculation is perhaps we'll see similar kind of relief for 2021. Time will tell. For your cafeteria plan, you had the ability to allow participants to prospectively change or revoke their election for your group health plan, prospectively change or revoke their election under the healthcare or dependent care flexible spending account plans. Now, you could have implemented any or all of these provisions. You were not required to implement any of them. You could pick and choose which ones you wanted to offer to your employees. Some of my clients offered the ability to change the election on healthcare and dependent care flexible spending accounts, but did not allow folks to revoke their coverage under a group health plan or change that coverage unless some other event required it. You could also impose restrictions on the kinds of changes that could be made. For example, I had a number of clients say, you can only make this change to your election if you have made it by X date. And you are only allowed to make one change. You can't be coming in making multiple changes over this period of time. You could also say, and most plans would say, that you cannot change your election to an amount that is less than you have already received. So if you've already received $1,000 reimbursement from your healthcare flexible spending account, you can't come in now and change that election to $500. Remember, though, that these are prospective elections. There still is a prohibition against retroactive changes to elections for cafeteria plan elections, like particularly with respect to healthcare and dependent care accounts. And the use it or lose it rule still applies. So if you get to the end of the plan year or the end of your grace period and the participant still has unused amounts in their account, they will be required to forfeit it. There's no relief from the use it or lose it rule or from the notion of making retroactive changes. Unless we see further guidance from the IRS, those rules still apply. Now, you probably have already dealt with this, perhaps by communicating it to your employees, perhaps with some kind of communication update to your summary plan description, but the formal plan amendment won't be required until sometime in 2021. And we'll talk about the amendment deadlines in just a minute. Also, with respect to cafeteria plans, you could also allow folks to have access to the unused balances in their accounts during the rest of 2020. So for example, if you have a plan year that ends on June 30th, or you use the 2.5-month grace period that ends on March 15th of 2020, if either of those applies to your cafeteria plan, and folks had monies left in their accounts as of that date, you could allow them to have access to those unused amounts through the end of 2020, through December 31st, 2020. I would caution you, though, that you need to carefully coordinate that provision with any carryovers that you might have in your healthcare flexible spending account, if you have that feature. And it also might affect these folks' ability to make contributions to their health savings accounts. The IRS guidance contains some examples around all of that. So I would encourage you to work with your third-party administrators and your benefits consultants to create careful communications to your employees to avoid any surprises in 2021. But again, think through that very carefully before making that available. Finally, for cafeteria plans, over-the-counter medications and certain other supplies must be reimbursed. This is a change in the law, so your plan must allow for this. If you do have a carryover feature for your healthcare flexible spending account plan, that limit has increased from $500 to $550. And then, as I mentioned, amendments for all of these changes are required by the end of December 2021. So you've got some time to get the formal plan amendment done. It's possible that you've already drafted something, and that's perfectly fine. We may see model language come from the IRS next year, in which case you want to take a look at that language to see if revisions are needed to your amendment. But otherwise, you do have until the end of 2021 to get that formal plan amendment in place. With respect to the changes that were made by the Secure Act and the CARES Act for retirement plans, the deadline for that amendment is the end of 2022. So a lot can happen between now and the end of 2022, but you do have some time to get the formal plan amendments for those various provisions into your plan document. As luck would have it, we are soon entering into a period of time when you're going to have to restate your plan. You may recall that the IRS has a 6-year time period, or a 6-year cycle, if you will, when plans have to be updated for recent legislation and regulations. And we're entering into another one of those cycles. It's possible that you've heard about this from your third-party administrator or your plan vendor, but if not, you will be soon, because we're entering into another 2-year window of time that you'll have to update your plan. And hopefully, you'll be able to coordinate that plan restatement with the amendment for the Secure Act and the CARES Act to minimize the number of documents that you have to adopt and execute for your plan. And with that, I will turn it over to Thomas.
And I'm going to give you a couple questions first. We have a few.
All right.
Let me pull these up.
Fire away.
First, regarding the Secure Act and the penalty-free withdrawals for birth or adoption, we have a question as to whether there's stipulations on what those withdrawal funds can be spent on. Is it, sort of limited to hospital bills or adoption agency fees, et cetera? And then a second part of that is, do they have to pay taxes on the withdrawal?
Well, they do have to pay taxes on the withdrawal. And I'm not aware, Thomas, maybe you are, but I'm not aware that there are any restrictions to what they use the withdrawal for. I would assume that they'd use it for hospital bills and expenses relating to the birth or the adoption of the child. But I don't recall seeing any restriction in the IRS guidance.
Yeah, I haven't seen anything in particular. So as long as it's related to.
Right, exactly, yeah.
It's fine. And then a second question. What do you think there will be, the likelihood is that there'll be an extension of the CARES Act or something else that would continue flexibility into 2021?
Well, right, yeah.
Particularly for making mid-year changes on FSAs.
Right, yeah. And as I said, right now the legislation and the regulations just provide for making these changes in 2020. But as we continue on with this pandemic, I think there's some likelihood that we're going to see similar relief for 2021. I guess time will tell. But if things continue as they currently are, And I'm getting a number of questions from clients, and I'm seeing that a number of questions are being raised to the IRS about prospective changes to elections, or even trying to make retroactive changes to elections. I would venture to guess that we're going to see some relief in 2021 as well. That's my prediction.
I think that that's reasonable, though they probably won't get it out as quickly as we would like.
No, that's right. It won't be before the end of the year. I can guarantee you that it'll come sometime next year. There's no question about that. Yeah.
Always dangerous to predict these things.
Well, I can predict, but I won't commit to a timeline. So how about that?
Speaking of some of the flexibility, that will nicely segue into the next topic, which is extended deadlines and periods that has come out of COVID. Last May, there was a joint notice from the Department of Labor and IRS retroactive to March 1st of 2020 that basically extended a large amount of deadlines for employees on health and welfare plans and retirement plans to the end of the outbreak period, is what they called it. And that's 60 days past the end of the national emergency. And the question is, when will it end? Because that national emergency keeps on getting punted down the road. And in fact, it was last renewed on October 23rd for an additional 90 days. That means that the end of the national emergency itself won't occur prior to January 21st. And the outbreak period won't end until March 22nd of 2021. So there's actually a huge period of flexibility, I would say, for enrollment in your group health plans and deadlines generally. So what's affected? First, your HIPAA special enrollment rights, the 30-day, generally 30-day elections when, enrollment periods for when someone loses coverage with another employer, they have a new dependent, they lose Medicaid coverage. It's also 60 days in the case of CHIP plans, children's health insurance plans. So that all gets punted until 30 days past or 60 days past the end of the outbreak period. The dates for providing the COBRA election notices for employers actually is also kicked. Generally, if you're using an outside service provider, that's 14 days after termination of employment. If you're doing it yourself, it's 44 days. But now you actually have a pretty long period to provide the election notice. We wouldn't advise waiting, though, because ultimately, if you delay, you're going to forget to do your election notice. And so keeping as close as you can to the normal timeline is still a great idea. Just you don't need to worry so much about liability to the Department of Labor if you're a couple days late. The COBRA election period itself, generally 60 days after they receive that notice, also got punted. So 60 days past the end of the outbreak period once again. So you're talking about 2 months past the end of March next year, for which someone could theoretically elect COBRA all the way back to the beginning of March of this year. In truth, it's probably not going to happen with any regularity, but it does show a certain advantage to keeping up with some of these COBRA eligible participants, basically making sure you get your notices out and making sure you get responses if you can, so that you don't have to keep up with them sort of for the foreseeable future, I would say. They also have delays in when they have to pay their premiums. And this can, once again, be pretty substantial. Usually you only have to pay your first premium 45 days after you've elected COBRA. Well, now you don't have to elect COBRA until next year. When are you going to start paying your premiums? And that occurs for both the initial payment and ongoing payments. One of the reasons why you want to push regular contact with these COBRA participants is they're going to have to back pay all of this stuff when they actually try to get coverage. And it's going to end up being a very large sum of money if they try to enroll next year. Try to keep up with your participants is sort of the best advice we can give there. Other deadlines that were extended, the qualifying event deadline, generally 60 days past the qualifying event for getting into the health plan or making changes to your health plans. This is, marriage, birth, adoption, also determination of disability. Now they could do that more than a year, theoretically, after it actually happens. They also extended the deadlines for filing benefit claims, filing appeals. The deadline for filing an appeal for a group health plan is 180 days following that determination. Well, now it's 180 days past the outbreak period. So you're looking at, September 18th, 2021 at a minimum for a deadline for filing an appeal on a health plan. It's gotten ludicrously long, is basically what we're saying. But that doesn't mean you can't keep in touch with people and try to move things along and get assurances, I suppose, that they're not filing appeals. Also, appeal requests for external reviews pushed back, and for perfecting their external review claims. If they make an external review claim and there's missing information, they just have a currently very open time period for fixing those. And the reason why this is important is basically claims procedures are one of the best protections that employee benefits plans have against lawsuit. Basically, people fail to follow the claims procedures, they get kicked out of court, et cetera. And now it's going to be more difficult to do that. So keep up contact is one of the best ways to handle that. It's not all just for the participants, though. DOL also provided basically a non-enforcement notice on the provision of notices and disclosures and documents during the outbreak period. Now, this doesn't mean you don't provide, blackout notices or your SPDs or anything of the sort. What it means is that you're not held by the DOL, at least, to strict timelines through this process. So essentially, act in good faith, get the stuff out as soon as you can. Don't worry so much that you did it within 30 days, within 90 days, whatever it is, just try to get them out when you can. The other thing they did is they loosened some of the rules about distribution through email, text, website access, so that you don't necessarily have to send paper copies all the time. They recognize that a remote workforce, maybe that's not going to work quite so well. One thing that did also happen earlier this year is the DOL revamped their rules for electronic disclosure for retirement plans, essentially bringing it up to, I'd say, 2010 levels, as opposed to the 1990s levels that they used to be in. The gist is, if you're not already making electronic disclosures of your retirement plan materials, at least, it might not be a bad time to revisit that choice and consider the possibility for electronic distribution. I know a lot of employers have already made that shift at some level, despite the awkward guidance that the DOL has provided in the past. But if you're not, it's not a bad time to look again. Okay, so aside from strict guidance, back to COVID. We know we're all so tired of talking about COVID, but it is having impacts on other benefit plans in, I guess, not completely expected ways. And that's primarily just because of the length of the impact time-wise. So furloughs and reduced work schedules, et cetera, are impacting salaries. And coming in 2021, that's going to mean that life insurance benefits and disability benefits may not be worth as much compared to this year or your prior years. We have seen some employers find success working with the insurance companies to get the look-back period for compensation adjusted to reflect pre-COVID level compensation levels. The incentive for the insurance companies is that they get larger premiums. The incentive for the company is you provide a more useful benefit in a time when, frankly, life insurance and disability seem like more important benefits. The next major issue, and I really wish we had a room right now, because I'd love to know how many people have taken a good long vacation, because I certainly haven't. And vacation balances are piling up in a lot of companies. This is going to mean larger than expected carryover if you have that in your policy, or a larger than expected forfeiture of vacation if you have a use it or lose it policy. And if this is happening to your company, it's a good idea to look at this policy and determine whether any adjustments could be made to it, or your leave policies generally, to allow employees to better utilize that time, because they're not going on that trip to Bermuda, essentially. So frankly, these days, I don't even know that we're going to that trip to St. Paul in Minneapolis. Yeah. But anyway, essentially, it isn't something just to do willy-nilly, though. So you don't allow cash outs of these amounts for employees. They don't get to choose one way or the other. And the reason why is because that is viewed as constructive receipt by the IRS, and it creates a tax liability for the employees the moment they're given the choice. It doesn't matter whether or not they actually got the money yet. So you don't want to just drop into that without thinking it through completely. And so we're going to go through a couple options for dealing with leave. There are others, such as imposing annual carryover caps, et cetera. But these are more on the line of leave sharing programs, essentially. The first is a new one. It's COVID leave donation. The IRS came out with this earlier this year, and it allows a charitable contribution of unused leave by your employees. Essentially, the tax deduction goes to the employer, because the employer makes the contribution of the value of the leave, not to the employee. But the employee doesn't need to recognize wages for this amount. This, for the majority of your employees, is a great deal. Essentially, they don't have to recognize wages, and they're essentially giving up a tax deduction that they probably wouldn't have been taking anyway, because they don't itemize their individual taxes. So a useful program, but we don't have a lot of time to use it, unfortunately. There are sort of restrictions in here. First, you have to use that donation for COVID-19 victim relief. So if you're setting it up quickly, it might not be a bad idea to provide some suggestions when setting up a program. And then in two, it has to be contributed by the end of this year. Could this be extended? Yes. We have not heard anything of the sort yet from the IRS, but it wouldn't take an act of Congress to do so. Two major other options, though, for dealing with leave sharing have always been there, and that's medical emergency and major disaster leave sharing options. I tend to see these on a more regular basis in areas of the country where they have to deal with major natural disasters with regularity, sort of major fires, hurricane areas, et cetera. But there's no reason why you can't set them up in the upper Midwest just as much. And it's basically some employees donate a portion of their leave to a pool, other employees use it and pay the taxes on that paid leave. And it can be a great way for people to use up some of that leave and help their coworkers, essentially. And definitely something to consider if you have a lot of extra leave that nobody knows what to do with. Leaving the world of leave, one of the biggest impacts that the workforce generally is seeing is the departure of women from the workforce. This has been getting more coverage in the broader media over the past month, and that is particularly because the Department of Labor came out with workforce statistics for August and September, where they talked about 1.1 million people leaving the workforce, and 860,000 of those were women. So it's a 4-to-1 ratio. Women are leaving the workforce faster than men. In fact, the drop in the unemployment rate has a lot more to do with people leaving the workforce right now than large job gains. And so it's not entirely surprising that this is happening. We have, large caregiving needs at home with children who aren't in school. But the disparate impact here has a lot to do with sort of long-held issues with pay for women and sort of cultural precedents for expectations that women are the primary caregivers in their homes. So essentially, if you have a man and a woman in a home and one of them makes more money than the other, if you're going to make that choice as a couple, people tend to choose the person who's making more money, which leads the woman to leave the workforce rather than the man. I'm seeing this even on my LinkedIn page where, occasionally you'll see somebody talking about leaving the workforce. The worry is twofold. One, for the employees, it's difficult once you leave the workforce to get back in. You're giving up, obviously, promotions, wages, et cetera, and knowledge during the period you're outside of the workforce. You're also giving up retirement readiness because why? You're not earning wages, so you're not putting money into your retirement plan, but you're also not earning wages for Social Security. So this can have a longer-term impact than just the immediate loss of income for these families. For employers, you're losing gender diversity and racial diversity, actually, because a larger proportion of these women leaving the workforce are actually Latinas than any other racial group. Something that many employers have been working very, very hard to deal with over the past decades. This, from what I've seen, the drop has been essentially like losing a decade of growth in female participation in the workforce in a number of months. So, and then, the most simple stuff from the employer perspective, you've invested in these people. You want to keep your employees. It costs money to get new employees if you have the work for them to do. So what can you do about this? Well, part of it's benefits related. You need to make sure your employees know that you have benefit plans available to help them. There are wellness benefits, mental health benefits, employee assistance programs, financial counseling. All of these things can help people deal with the stress that they're feeling at home that's making them give up at work, essentially. You're not going to help everyone. Some people, this is a rational decision. They're thinking it through. But you want to make sure that they're utilizing all their tools at work before they make the decision to cut the cord, essentially. And so we really want to get that across, that you have a number of benefit options that help people that maybe they're not aware of enough. So a lot of this is about communication, and you can't do it when they've already made the decision. You have to move for this sort of prospectively and prepare your employees that might be having more difficulty than you realize. Leaving that sort of kind of bleak issue from my perspective, the simple thing that we added last because it happened last. This happened 2 weeks ago. We got the cost of living adjustments from the IRS. I was very surprised. I was in an investment committee meeting last week, and the administrator said there were no changes, which was a lie. I don't know why they said that. Deferrals are unchanged. So the $19,500 for pre-tax and Roth plus the $6,500 for catch-up, that is unchanged. But the annual additions for defined contributions has gone up for $1,000 to $58,000. The annual compensation limit increased $5,000 to $290,000. Highly compensated employee levels stayed the same, while the Social Security wage base went up a little bit. Medical flexible spending accounts remained at $2,750, but HSA contributions went up a little bit. So there's a mixed bag through here. A little more savings opportunities for employer contributions and HSA contributions, but the individual contributions remain approximately the same. And that is the quick and dirty. Now, looking here, we have a few other questions that have come up.
Yes, Thomas, I think you have two, and then I have one that I'll follow up on the FSA once you're finished.
Okay. So is the FPDs me?
The SPD is you, and the election time period. Yeah.
Can we provide SPDs when you provide enrollment information, or does it have to be after they enroll? There's no reason why you couldn't provide an SPD when they're enrolling in the retirement plan or with health and welfare plans. And then the second part of this is, can you provide via email and hyperlink where it's posted on our website or intranet site? Yes, you can. In fact, I was working with a client this year that is texting them out with a link to the company intranet when they do this, because they actually find it easier to keep track of people's phone numbers than their mobile phone numbers than their email addresses. So yes, you can do that. In terms of the retirement plan guidance, there's still a notice requirement related to that, where basically you get consent and they sort of are informed that they have the right to get a paper copy. So it's not perfect. You don't just get to forget paper entirely. But particularly with employees with regular access, you can just send that email to their workstation and with a hyperlink, and that is just fine as long as you've basically disclosed that they have a right to paper from the company. It's more of a difficulty with former employees who are still participants in your plan, sort of keeping track of them and making sure that they're sending out that you're sending out SPDs for them. In that context, you need consent still to get electronic only. If they don't provide that consent, you're still going to be sending paper to a few people. This particularly will impact older participants if you've got long gone deferred vested employee participants in your retirement plan, for instance.
So Thomas, maybe just a clarification for the active participants, would you recommend kind of a two-step process that one, you do an email blast that says, hey, check your phone. There's going to be a text or a link coming to the SPD. And if you want a paper copy, you can request it and then send out the link, obviously. Would that be kind of the process that you're thinking employers would use?
Yes. I mean, if you can set up, it's also useful, though, to set up a consent process, particularly either when people leave or when they're signing up for the plans, just where they, affirmatively elect to receive electronic distribution. It's just, it's a single point where you can tell them they get the right to a paper copy. Then it does not mean you're still going to have to occasionally send out a notice telling them, hey, you have a right to a paper copy. So. Right.
Yeah. Okay. All right. You want to take the next one too about the election period?
Yes. So did you hear correctly that employees have more than 30 days to change their benefit elections after a qualifying event due to COVID extensions? Yes, you did hear right. So, if they want to change their, status from single to group coverage in your health plan, they have until 30 days following the end of the emergency period, which is today. I flipped away from my notes. I had the date written down.
I think you said it was March. Yeah.
So the end of the outbreak period is March 22nd. So 30 days, it would be April 22nd, 2021. They could theoretically elect all the way back to March 1st, 2020. Do I think that that's going to happen to you? Not so much. But the truth is that the 30-day window really doesn't exist right now. And basically, if someone comes to you, you're probably, their change in their qualifying event occurred after March 1st, you're probably going to have to let them make an election change for the group health plan.
So there were two follow-up questions, Thomas. One is if there will be a resource that says all of the extension timelines. Have you seen anything further from the Department of Labor other than what we got maybe back in May?
Not in particular. We can post something. The problem here is that they continually extend the national emergency. So right. Really what it is there is a tolling of the period until 60 days after the end of the emergency. And so it will continue to be pushed. Yesterday there were over 100,000 cases reported in the United States. It's expected that this national emergency will be pushed forward again. Right now, I don't think I've heard anything to the contrary until frankly, there's probably a vaccine. We're going to see extension of this.
All right. And then there was a question around, the question says, but that's only if we as the employer decided we would take on that part of the act. And I'm not certain what act they're talking about, but I presume they mean the CARES Act.
I think this is thinking about the cafeteria plan elections. I'm talking
okay.
about.
You think that's what it's? It would. Hard to tell. If it's the cafeteria plan elections, yes, that's optional. You don't have to provide those mid-year elections for the cafeteria plans. That's totally up to you. And then you can implement some or all of them. I had a question as well relating to someone who had elected dependent care and due to COVID stopped their continued election. However, they still have a balance in their account and no future in sight to use it, and they want the money back. Anything on the horizon about that? And the short answer is there's nothing on the horizon right now. I don't know whether we'll see guidance from the IRS, but the most recent thing that I saw just today was that the IRS reminded us all that the use it or lose it rule still applies. And without further guidance or further relief, if that person has not used up their funds in their flexible spending account plan, then they will forfeit that money. And there's no way to get it back to them. You can't give them a cash payment or a bonus or anything like that. It's a use it or lose it rule. There was also a question, is the COBRA election only for health plan or can it be on life insurance elections too? Well, in Minnesota, life insurance has COBRA associated with it. It isn't true in every state. But have you seen anything with respect to extensions on that deadline, Thomas?
So I haven't, and I don't think that the COBRA extension at the state level would necessarily be impacted by the federal timeline adjustment. So there's no federal COBRA right for life insurance in a sense. So I don't think you're going to be able to push that back, but there hasn't been a lot of extra guidance on this either.
Yeah. And then there's a question about the 30-day special enrollment window, that it basically doesn't exist right now. So do we need to amend our plan to reflect that? I haven't had anybody amending plans to reflect these extended deadlines. And I don't know that it's required by the guidance. I think this is just an operational rule until we get through all of this pandemic.
And I would agree with that.
Okay. And then I guess maybe a clarification on one of my questions relating to the mid-year cafeteria plan election. It says if we did not decide to let employees make changes without a qualifying event, would we still let them make a change outside of the 30-day window? Just to be clear, these are special elections in the cafeteria plan that you can make available. Employees still have the ability to make changes to their cafeteria plan elections if they do have a qualifying event. The special rules under the CARES Act did not change that. These were designed to help employees deal with the fact that they may not be going to the doctor or they may not be having dependent care expenses, and giving them an opportunity to change their election to recognize that. So the qualifying event notice, the qualifying event changes in your cafeteria plan would still apply. And I would still probably impose that 30-day window on that type of election change. I don't believe that the deadline extensions that Thomas has been talking about necessarily affect the cafeteria plan elections for qualifying events. Thomas, would you agree with that, or do you have other thoughts?
Yeah, I think I'd agree with that. I suppose it's possible that they could try to, how would I put it? You'd be trying to impose a retroactive change on payroll, essentially. Yeah. It doesn't actually make a lot of sense to get that retroactive coverage from the cafeteria plan.
Exactly. And remember, we do have cafeteria plan regulations that say sort of each plan year is on its own. So elections from one year cannot affect an election in a prior or a future year. So with that in mind, I would basically use business as usual for qualifying event type changes, but some of these other special enrollment rights and things like that, that's what Thomas was talking about, things outside of the cafeteria plan. All right. Well, it looks like we have just about a minute left. So if there are other questions, we'd be certainly happy to take them. Otherwise, we do appreciate your time today. And if you do have questions, feel free to reach out to either one of us. We'll be happy to help in any way that we can. I know these are interesting times, as they say, but we certainly appreciate you taking the time to spend your lunch hour with us today on this webinar about the Employee Benefits Update.
Thank you so much.
Thank you very much, everybody. Take care.
Bye.
Bye-bye.